Criminal Law 1 or Substantive Law of Crimes or Indian Penal Code 1860, Part 2 Specific Offences, that is sections 121 to 511. Summary of the topic, that is Part 2. Dear student friends, today I wish to take up in English language Criminal Law Part 1 or Indian Penal Code specific offences from sections 121 to 511, that is chapter 6 to chapter 23 of this Indian Penal Code. This is the summary lecture. In the some time back, I uploaded both in English language and Telugu language general principles from sections 1 to 120b. Yesterday, I uploaded this lecture, this topic in Telugu language. Today, I am uploading this in English language. Dear friends, you remember some students are expressing doubts. I have uploaded so far 221 lectures. This is 222nd lecture. Out of this, around 170 lectures are absolutely in English language. Around 50 lectures are in Telugu. I started delivering lectures in Telugu recently after completing 145 lectures at the request of my student friends from Telugu states. I started uploading, and in course of time, to justify both the languages, I have been uploading not only in English but also in Telugu immediately. Please note that you have enough number of lectures on English language also. The number of lectures in English are around 170, while the lectures in Telugu language are around only 50. So this is for information, and some students are requesting me to upload with different subjects and different topics. But in the first instance, I wish to complete first year revised lectures both in English medium and Telugu medium, and immediately I will proceed to Muslim law, law succession, and other important chapters. Please note that I sincerely promise to upload almost all the 30 subjects. I promise to spare my full time for this work and for the convenience of my student friends, as a token of love, affection, and respect of my student friends who are instrumental for what I am now. I will show this gratitude. You need not doubt about my promise. Now, today, I wish to take in the last class general principles. I explained in detail overall idea I have given on general principles, and in that context, I enlightened you about the criminal law amendments, in particular 2013 criminal law amendments, which brought about some changes in Evidence Act, Indian Penal Code, and Indian Penal Code, in Criminal Procedure Code, and Evidence. And 2018 Amendment Act brought about drastic changes, drastic changes in expanding punishment to culprits who are guilty of sexual offences. And this 2018 Amendment Act brought out about some changes in expanding section 354 regarding offences relating to modesty of women and all these things. Yet the particular chapter I will explain in detail about all these things. Dear friends, please note that part 1 general principles is limited. This part 2 is a voluminous subject, and this part 2, in some universities, general principles is one subject, specific offences is one subject, and in some most of the universities, both principles and specific are enlisted in only one subject. So anyway, the notable point here is chapter 6 to 23 of Indian Penal Code, containing sections 121 to 511, deal with various specific offences. This prescribe punishment, they define various offences and prescribe punishments for the respective offences. At the time of code, the punishments were not that much severe and serious in particular offences against women. Now, the criminal amendments brought about drastic changes and made the punishments very severe in certain respects, particularly in case of offences against women and children. Now, coming to the point I told in the last class, when Indian Penal Code came into Indian Penal Code 1860, which came into force on 1st January 2062. But at the time of passing of the act, there were about 511 sections. In course of amendments from time to time, to meet the socio-economic changes, so many amendments were made. I told in the last class there are 78 amendment acts were passed, and 2000 Criminal Amendment Act is latest, and subsequent to Jammu and Kashmir, Jammu and Kashmir Reorganization Act 2019, and there are about 78 amendment acts that brought about changes in Indian Penal Code. As a consequence of these 78 amendment acts, at present there are about 576 sections in the Indian Penal Code. Totally 23 subjects for 3 amended chapters, 23 chapters originally, 3 by subsequent amendment, 3 chapters are added. Chapter 5A was added, containing section 120A and 120B, speaking about criminal conspiracy. Section 9A was incorporated, expanding section 110, 171 relating to offences in respect of election irregularities, and section 20A was added by chapter 20A was inserted, containing section 498A regarding cruelty by husband and collaterals towards married woman. These aspects I will explain in detail, but here some section 121 to 513, there are about 20 chapters, including the amended chapters. But however, the beginning chapters are all chapters we must study. But however, the chapter from the chapter 16th chapter, 6 to 15 chapters are not of that much important. They are also important, but not of that much important. And 16th chapter is very important because that is offences against human body. Subsequent chapters, offences against property, and 18th chapter, offences against marriage. These offences against human body, offences against property, and offences against marriage are very important from examination point of view, and also offences against state, first chapter, also is important from examination point of view. Since this is summary lecture, I will enlighten you in brief about what are the various subjects, what are these various chapters, what topics they are discussing, what do the topics mean. I will simply explain, and after completion of this lecture, I will take up general principles, important topics, starting from elements of crime, stages of crime, and immediately theories and kinds of punishment. The topic is common for 3 subjects: criminology and criminal administration subject, legal theory or jurisprudence subject, and IPC. The theories and kinds of punishment is the topic prescribed for study in three subjects that I will take up. And common intention, common object. This joint liability is common in every subject, but that is torts and contracts also. That joint and constructive liability with reference to section 34 and 149, I will explain in detail. And then abatement, defenses, the most important out of all the defenses, the most important defenses, that is that is most important defense, that is insanity section 84, and right of private defense from 96 to 2000. In the last class I gave summary lecture on part 1, general principles and defenses. So general principles and defenses. Here in this specific offenses, I will explain you what are these various chapters that are dealing with specific offenses, what are the respective punishments. All these aspects I will explain one by one. First of all, let me complete this, then I will go to principles, high topics, and this. But whatever after complete, you give novel reading of this Indian Penal Code, that is summary, either some novel reading or summary lectures of mine. If you don't have time to give novel reading, you see the summary lectures part 1 and part 2, these two lectures, and then straight away go to culpable homicide murder, and then elements of crime with reference to doctrine of mens rea. Immediately you go to common intention, common object. Immediately you go to insanity, the insanity and private defense. Like that, what to read, how to read, all these aspects also I will explain you in detail for your information. So before starting the lecture, let me take just half minute to pray God, pay homage to my reverend parents, late Rega Apparo and late Srimati Kantaratnam, my eldest brother, Professor Rega Jagan Mohan Rao, my wife, Mrs. Baliwada Rega Tirumala Gauri, my academic associate, and I express my heartfelt gratitude to all my godfathers who are responsible for what I am now, and it's my duty to express heartfelt thanks to each and every other other whose articles and research papers I am making use of from internet, and finally it is my duty to express my deep sense of gratitude to my students friends who are instrumental for what I am now. Uh, so the now this specific offences, chapter 6 to 23, including chapters 9a and 20a, containing sections 121 to 511 of the Indian Penal Code, deal with various specific offences. What is principle, what is specific, I explained in detail in so many cases. For every offence, the principles are available. Basically, the principles are present for every offence, but every offence will have some special features. Depending upon that special feature, depending upon that special feature, a particular offence is identified as theft or robbery, dacoity, culpable homicide, murder, rape, kidnap, abduction, like that. These aspects I explained in the last class, general principle. And the first sixth chapter is offences. Again, among all these chapters, 20 I told you, offense against human body, offense against property, and offense against marriage are important. And however, let me take up the first chapter. Let me tell you what is what. And sixth chapter containing section 121 to 130 of the penal code, speak about two offences. Two offences. That is two offences against the state. One is waging war and sedition. One is one is waging war. Waging war. According to section, this waging war means whoever is responsible for waging war, waging what, declaring war, the person who is responsible for hostilities between two countries, and who is either he himself is responsible for a declaration of war, or he himself he has made conspiracy, he conspired with somebody for declare for war, or he has abetted somebody, or he himself responsible, or he has abetted, he has conspired, whatsoever he may be, the person who is responsible or instrumental for war is guilty of this waging war. He is seriously punished with death sentence. But this offense can be is punishable at the intention stage only, at the very intention stage only. Generally, in stages of crime, intention, preparation, attempt, and accomplishment. And for most of the offences, the person is punished for attempt and accomplishment, but it is not possible to in sometimes the preparation also the person is attempted at preparation. Intention is intangible, one cannot find out what is the intention, what is there in one's own mind cannot be detectable except on except in extraordinary technical skill like lie detectors, like that. So whatever it may be, dear friend, section chapter 6 containing section 121 to 130 of the Indian Penal Code deal with offense of waging war and sedition. SEDITION 124A deal with sedition. Sedition means the person who is responsible to spoiling the minds of the people by his speeches, by his activities, and to make the people revolt against the government. That person is called. That person is called. That person is guilty of the offense of sedition. Section 124 speaks about offense against governor or president of India. If any person instigates the governor of a state or president of India to do an act which he ought not to do, the president or governor, and prevent that person to do a particular act, that person is guilty of guilty under section 124. That person is punishable up to life imprisonment, death sentence, fine, for both fine and death sentence or life imprisonment, as the case may be. So here, according to section 124, suppose some petition is pending before the president office, some another co-terrorist or co-culprit somehow or other approaches the president of India or governor to give mercy petition, otherwise I will kill you, like that. So for example, you may doubt about how it is possible to attack governor or president of India, because it can be done by the security people, as in the case of Mrs. Indira Gandhi. Nobody can come around, nobody can venture to come around prime minister, president, and such high dignitaries. It is only the security people would be able to do, as in the case of Mrs. Indira Gandhi. So this is waging war, attacking president or governor to do a lawful, to prevent them from doing a lawful act, or to instigate them to do some illegal act. Say these are the such like offences, whether the person himself commits it, abets somebody, or enters into a criminal agreement by criminal conspiracy, that person is liable. This is what section 6 tells you. Chapter 6. Chapter 7 containing section 131 to 140 deal with the offences against Army, Navy, Air Force. So one must be deeply indebted, every citizen must be deeply indebted to Army, Navy and Air Force personnel, that is defense personnel, who are simply sacrificing their lives for the cause of public welfare, people for. But for their security at border, we will not be able to live happily. We will not be able to live happily in our home, at our home. So that is why we can physically witness in this TVs, we are witnessing the war between incidents of war between Russia and Ukraine, how the people, how the soldiers are being killed by bombing and other processes, in spite of the reason that they would die at any moment. How actively they are participating, in the sense the person's mind, how their person mind is mentally prepared to die. They treat death like a very small issue. This is what the greatness of the personnel of Army, Navy, and Air Force. So the offences. This chapter 7 speaks about containing sections 131 to 140, lays down the provisions relating to speaks about the offences against Army, Navy, and Air Force. And eighth chapter 141 to 160, 141 section chapter 8 containing section 141 to 160 deal with offences relating to public tranquility. So unless there is a peace in the society, we won't be able to do. If there are any unlawful assemblies, riots, affrays, all these things, there is a lot of societal unrest, public unrest. We have to, so for example, during curfew and agitations within the town, there is a full of police, military, and such times we won't be able to come out. We cannot have any peace of mind. We will be confining to room houses, closing the doors, closing the doors. So that is why the fundamental duty, the main duty of any state is to, the primary responsibility of any state is to maintain law and order and establish peace. In order to maintain law and order, establish peace, some authorities are working. Those authorities are police, police, public prosecutors, police, criminal courts, and all these authorities are working. What are the various authorities that are serving the people to ensure peace and security? These aspects you study in criminal procedure code. I delivered lectures on in this topic for criminal procedure code. This subject, criminal procedure code, you are expected to study in final year. So this public public tranquility means, if any disturbances are there in society, in the town, if there are any agitations, vehicles burning, railway stations burning, such situations are there. If they're due to some political crisis or other unwanted situations, the law and order will be affected. The state police will not be able to control. Then the state will request the center to send police force. Then central police will come and keep the situation under control. So for these offences, the police may be empowered to take up step by step to ensure peace and security. In first instance, they will take lathi charge, then next they open gas, and the next open firing if necessary under the instructions of a magistrate or local district executive magistrate that is collected. And all these aspects you study in criminal procedure also. So what are the offences that take place in the course of to threaten the peace and security of the state. These aspects we study in this chapter, in this chapter 18, chapter 8, sections 141 to 160 deal with these offences against public tranquility. For example, unlawful assemblies, rights, affrays. Unlawful assemblies means five and above meet together to take up some agitation, garrows, buns and all. That amount that assembly constitute unlawful assembly, they are punishable. And rights means unlawful assembly with violence. Unlawful assembly with violence by garrows, strikes and all. This unlawful assembly may be taken up. Rights means unlawful assembly, aggravated form of unlawful assembly resulting in violence and beating, attacking government properties, private properties, and creating public disturbance that public will not be able to move. And next one is affray. Affray in the sense the generally the unlawful assembly rights may be for the benefit of due to quarrel between two important persons in that society, maybe two rich people or maybe two political rivals or maybe two rivals. And if those two parties quarrel in public, it will create lot of tension in the public that public won't be able to move. So there are, for example, there are some two villains in a movie. If the people from both the parties quarrel in the public place, the members of the public get shivered and run away into their homes and closing the doors. That is what is called affray. This type of offences are dealt with under chapter 8, containing sections 141 to 160. Next chapter, chapter 9. Chapter 9 contains section 166, 166 to section 161 to 165. These five sections were deleted by subsequent criminal law amendment. So there is after 160 we discuss about 166 to 170 under chapter 9. These sections relating to deal with offences committed by public servants. All the state government employees and central government employees are the public servants. See, offences relating to public servant in the sense bribery, misappropriation of government funds, and all these things come within the category. If the public servants indulge in corruption, misappropriation, breach of trust, and such offences, they are punishable. What are the offences? What are the punishments? We have to discuss in chapter 9, containing section 166 to 170. These sections deal with offences committed by the public servants. For example, lawyers, for example, public prosecutors, collectors, secretaries, tahsildars, and secretaries. So many government servants, engaged in irrigation, what not, all departments, whoever is the government employee, state government employee, or central government employee is deemed to be a public servant. So this is what we study regarding corruption, misappropriation of property, etc. by these things. And next chapter is 9A, this was added to Indian Penal Code by subsequent amendment act. That is, this section 171 was amended. This section 171 to 171I, say 171A, B, C, D, E, F, I. All these sections deal with offences relating to elections. You know, dear friends, every party, political party and rival party try their level best to come to power. They make so many promises. They indulge in sometimes they indulge in lot of irregularities like rigging, capturing, and spending money, outweighing the violating the rules of election laws and distributing money. So many election. What are the election offences we physically witness during elections time? So that is why in Indira Nehru versus Rajnarayan case, Miss Rajnarayan sued Mrs. Indira Gandhi, stating that she indulged in lots of irregularity, misusing her political power and misusing governmental machinery to win the election, and like that. So what are the various offenses during relating to election and during the course of election? These aspects would be dealt with under this chapter 9A, sections 171 to 171I. All these sections deal with election offenses. Now section 10, chapter 10 containing sections 172 to 180 lay down the provisions relating to contempts of and lawful authority and public servants. So here, being every citizen is under obligation and duty to obey the orders of government, judiciary, and public servants. Public servant. Suppose there is a heavy rain, and the public unable to move anywhere. In view of keeping in mind the safety and security of public, the collector may order existing companies in the city to declare holiday. As per collector order, must be obliged by the managing director of the local companies and to declare holiday. So that is what, if any managing director or chairman of any company do not declare holiday and restore functioning, he is liable. So that is why similarly the court may give whatever orders the court are given, they must be strictly adhered to. Whatever orders issued by government servant, they must be strictly adhered to by the citizens. So similarly, tax payment of tax. If anybody doesn't pay a tax and the income tax authority issues notice and to pay, if he doesn't pay, that is breach of. And court, certain rules and regulations are to be complied with. So I am senior most advocate drawing lakhs and crores of money, and that judge who entries was is just above the age, is equal to the his age is equal to my son's age. If he contacts a bench, I need not get up, I can do anything, is what even a leading lawyer, elderly lawyer, cannot say. When once a judge enters into the court hall to his bench, everybody in the court hall must get up and show respect. If anybody doesn't do so, it amounts to contempt of court. If anybody speaks in cell phone or speaks to somebody, that also amounts to contempt of court. And if anybody criticizes the judgment of court, and if anybody outweighs the personality of any judge or judicial officer, it constitutes contempt of court. For that contempt of court, civil and criminal punishments can be awarded. So that is why when any order is we receive from public servant, some police officer or government officer like Tahsildar or collector or any official administrator, public administrator, The individuals in the society must strictly adhere to those orders and act according to, that is in consonance with that order they must act. Suppose summons are issued, the one must obey summons. You should come to court and give evidence. Summons are issued, that person must go to court and give evidence that his presence, suppose he is an employee, will be treated on duty. The respective head of the institution should treat his officers absence for attending court in response to summons will be treated as duty leave. These are the various issues. If any contempt take place, and if any contempt is there in respect of all these orders, it constitutes contempt of public authority or court, and that person will be punishable. What are those activities and punish offences? How they are punished will be studied under this chapter 10, section 172 to 190 of the Indian Penal Code. Next chapter, 11th chapter. This 11th chapter contains sections 191 to 229A. So this is this chapter containing 191 to 229A deal with offences against public justice and false evidence. So here, whenever whoever goes to court, he must give evidence to the best of his knowledge. If anybody gives public false evidence, if it is detected that he gave a false evidence, he will be punished. He will be punished. So not only if even the abettor who instigates, who employs somebody to give public evidence, also is punishable, is having same responsibility and punishable. So whoever approaches court, gives evidence, must give evidence to the best of his knowledge, that the state he should make such statement which are absolutely true. He should not give any false evidence. He should not produce any false document, and these are the he should not behave. So she should not commit such an act that constitutes contempt of court. Suppose if the individuals in the court hall are required to switch off the cell phone, if they don't switch off the cell phone, if the cell phone rings or he speaks, it amounts to contempt of court. That particular person can be punished under the one section, under some section under this chapter 11. Next one is 12th chapter, speaks about counterfeiting of quotes and stamps. We know fake notes, fake government notes. How the government currency is having value. There are so many government stamps, 100 rupees stamps, 500 rupees stamps, 50 rupees stamps, like that. There are various stamps are there. We had in newspaper the stamp paper scam. Some persons were arrested and actions were taken. So like how fake currency, this is with reference to delivery of fake currency, accepting of fake currency, inserting fake currency and good currency bundle. So counterfeiting of coins and fake currency. So suppose in some coins are fake coins, some currency notes are fake, some court fee stamps also are fake. Knowingly somebody may be in possession of fake currency or fake coin or fake stamp unknowingly. When once it is detected, it must be destroyed. For example, a customer goes to bank to deposit some 1 lakh. 1 lakh. In that 1 lakh, some 500 to 500 notes are found to be fake. Then that counter, the cashier will advise him to burn it on the spot. So then the customer must burn it. He must burn it. And otherwise, if he doesn't agree for that, if they file case, that person is responsible. Sometimes a person delivers fake currency knowingly. Sometimes a person delivers fake currency unknowingly. So these are the these things, these wrongs committed by customers. Sometimes bankers also, sometimes such offences are committed, and in the public it is not possible to everybody. We cannot expect everybody is having knowledge about what is real currency, what is fake currency. Even then, no, even a good man receives fake currency. At the same time, he will deliver the fake currency to somebody. There are in such way, in so many cases, fake currencies are being transferred from one person to another. They are in circulation, but only persons having some technical knowledge, technical know-how, only will be able to find out this fake currency or fake coins. That is, the offences relating to counterfeiting of fake currency and fake stamps are discussed under chapter 12, containing sections 230 to 263A of the Indian Penal Code. Next one is chapter 13, contains sections 264 to 267. This chapter deals with the offences relating to weights and measures. So every person, every teller, whoever is taking money must give appropriate weight, proper weight only. The weights and measures must be real, genuine, and accurate. There should not be any false or incorrect weights and measures. Suppose when we go to petrol pump to pay petrol to our vehicle, he must give pure petrol. It should not be adulterated. It should not be adulterated. If 5 liters is petrol is to be pumped, it must be 5 liters only. Some 10 to some quarter liter or less than quarter liter should not be misappropriated. So for this reason, government officials, that is the officials of action measures, visit petrol pumps and other places which are selling the consumer products, whether liquid or solid or gas, whatsoever. They will inspect. If there is any defect is there, if they are selling defective or adulterative products, cases will be filed, and those offences are punished. What are the offences, how they are punished, is explained under section C 264 to 267 under chapter 13. Next one is offences affecting public health. So every individual has a duty and responsibility to see that whatever activity he is taking, his act should not cause any injury or damage to surrounding people. He must take care of public health. Public health. Suppose a man wants to take up a manufacturing process producing foul smell or poisonous gas, he must not do that in a residential locality. You must go away to far away place, industrial location, and then you should take up that. Suppose a man is taking up some grinding machine or chili powder machine, and when once the chili powder machine is being run, the vapors of chili will scatter in air and will cause cold and cough to surrounding people. In such a case, those people make a complaint. You should close that chili powder flour mill, chili powder flour mill. Similarly, when a shopman is selling the product, they must not be adulterated. One should not add stones in rice. One should not add one floor in another floor. Sugar must not be adulterated. Tea, coffee, powders, etc. All consumable products should not be adulterated with superior quality products should not be adulterated with inferior quality product. If it is just like Srinivas Mal's case, if inspection committee foods and if any food inspectors come and check if adulterators goods are there, cases will be cases will be filed and they will be dragged to court and they will be severely punished and maybe imprisoned if necessary. These aspects are explained under this chapter 14, offences against public health. In addition to that, public nuisance, adulteration of public nuisance is when you are using some suppose your house is located on the road, when you have your drainage, you should have proper pumping system. If there is no proper plumbing system arrangement, you are discharging all the water towards the public highway. When once you discharge all the use the drainage water towards public highway, the highway will be slippery. The people walking on the road will feel lot of inconvenience, and some people may fall down, some vehicles may be slipped, and motorcyclists may fall down, and all these things. When an act, if the act of nuisance causes one individual or group of individual, that is to your neighbor or opposite man, then it is private nuisance, it is tort. But if it causes inconvenience to public at large, it is called public nuisance. Public nuisance is not only tort but also a crime for which you are responsible. The local magistrate will take action against you to remove the public nuisance, failing which you would be punished and fined. That is chapter 14. Chapter 15 relating to chapter 15 contains sections 195 to 198 relating to offences against religion. The offences against religion, Ram Janmabhoomi, Babri Masjid is the best example, and Article 25 to 28 of Indian Constitution also lay down various provisions relating to constitutional protection of religion also. Ours is secular state. India is a secular state. No religion is our own. Our national bird is peacock. Our national animal is tiger. But we don't have any national religion. We must not say that Hindu is national religion or Islam is national religion or Christian is national religion. If we do so, it will be a serious offense. So that is why no Hindu should criticize Christian, no Christian should criticize the Hindu. One should not speak negative about other religion. One may respect his own religion, but one must not respect, one must not humiliate, insult any religion, any other religion, or including his own religion. One must not accuse his own religion because where is God? There is no God. These are people are innocent people, unnecessarily going to temple, unnecessarily worshipping the God. All these things, such types of words are very dangerous to profess. If anybody makes a statement, it will create lot of inconvenience. They will hurt the such statements hurt the feelings of the religious lovers who worship the God very sincerely and honestly. If anybody makes any statement or commits any act defaming other religion, he will be punished. So these are the issues relating to that. Ram Janmabhoomi, Babri Masjid is the best example, and in the recent past we are finding some statutes of some Hindu murtis or other religion murtis being insulted by demolishing or other things. So such things attract this chapter, and those persons will be severely punished and fined. That is 15th chapter speaks about religion. The 16th chapter is the most important chapter, offences against human body, which I will explain in detail each and every one. Culpable homicide, murder, kidnap, abduction, rape, wrongful confinement, all these things are there. So, offenses against human body means if one human body kills another human body, it becomes a homicide. Intentional killing is if one human being is killed by another human being, it is called homicide. homicide. If one human being intentionally kills another human being, that is intentional killing. Intentional killing. That intentional killing of one person by another person may be either culpable homicide or murder. If it is the serious nature of killing, it is murder. It is a slight nature of killing and a little ray of hope for survival, and that is culpable homicide. So culpable homicide results in death, murder results in death, but in murder, death is immediate act. In culpable homicide, death is ultimate act. Though both the offences result in death, but there is a slight difference is there. This I will explain in detail point wise. That is culpable homicide murder. Section 304 299 defines culpable homicide. 304 gives punishment for culpable homicide. 300 defines murder. 302 prescribes punishment for murder. Similarly, next offense is hurt to grievous hurt to assault. Suppose one person scolds another person, inflicting lot of fear and threat. I will break your head. I will see that your body is floated in our village tank, like that, like that. If he speaks such a words without touching his body, so that by creating, inflicting very serious pains, mental pains, agony, that is what is called assault. Crying, scolding in a serious manner is assault. Aggravated form of assault is battery in law of torts, criminal force in this. So just touching body and slightly causing injury, that is criminal force, battery or criminal force. And beating amounts to hurt. Beating amounts to hurt. Beating on body, any part of the body resulting in some pain, that is hurt. Grievous hurt. Grievous hurt means loss of leg, loss of ear, loss of nose, loss of eye, loss of some limb is called grievous hurt. That is aggravated form of hurt is grievous hurt. And aggravated form of grievous hurt is culpable homicide. Aggravated form of culpable homicide is murder. So assault, aggravated serious or aggravated form of assault is hurt. Aggravated form of hurt is aggravated form of assault is criminal force. Aggravated form of criminal force is hurt. Aggravated form of hurt is grievous hurt. Aggravated form of grievous hurt is culpable homicide. Aggravated form of culpable homicide is murder. So that is why similarly in mens rea, common law doctrine of mens rea, that is mental element, evil mind, guilty mind, bad mind do harm. So that bad mind or guilty mind to do harm varies from situation to situation, offense to offense. To steal one's scooter is mens rea is less. To break the head, to stop a scooterist, stopping scooterist, breaking his head and taking away a scooter is mens rea is more. And killing somebody, taking away his property is the mens rea something more. Like that, there are variety of offences, various offences. For every offences, very often the degree or volume of mens rea varies from content of mens rea varies from time to time and situation to situation, offense to offense. So like that, the aggravated how mens rea varies from offense to offense. This aggravated for the nature of offense, the veracity varies from offense to offense. So this is what is called offense against human body. In this hurt to grievous hurt we study. Next we will study miscarriage of a woman, a pregnant woman. We know for property issues in movies also we see if a woman got pregnant and she is going to give birth to Vamsodharaka, the person who will be the natural legal heir of the entire property, and the rival person makes all attempts to spoil the pregnancy or kill that pregnant woman by doing certain acts and miscarriage and all, and a pregnant woman, a child in womb related, and child offences are there. For various offences are there, I will discuss in detail. And next one is rape. Next, rape is most important section. Where the time of opening, at the time of passing Indian Penal Code, 375 defines rape, 376 prescribed punishment for rape. Earlier, the punishment for rape was the definition of rape was limited, but the definition of rape under new amendment acts is expanded. The part of partial act also constituted as a full length of rape, and earlier the punishment for rape was maximum 10 years. Now life imprisonment it was made. Earlier life imprisonment as per one case 12 years. Life imprisonment means 14 years. In rare cases life imprisonment is 20 years. Now today life imprisonment is whole life till the last day of death. That is the natural life. Full natural life is life imprisonment today. And for offences against offences below the age of 12 years, the maximum punishment should be death sentence or life imprisonment. And for offense below the age of 12 years, the punishment must be death, like that. And after this um, 2012 case, nearby case, four culprits, three culprits were hanged, one culprit was minor. He was sent to correcting home and then released later. But at the time also there was a lot of consistent and unstinted demand to prescribe death sentence even to the minor also. But to that effect, the government of India made promise to bring about criminal amendment so as to make minor also sentenced to death, provided he indulged in that criminal activity in such a heinous way. These are the things, all these aspects, some of these aspects are explained in this thing. For atrocities, women against outweighing, see, affecting the modesty of women, criminal assaults and all, and section 354 is fully expanded. And women that is staking and sexual harassment 354A, staking 354B, voyeurism 354C, like that. Undressing women, for the punishments new sections are added. And similarly all these aspects in part 1 I explained. Acid attacks 270 was expanded. Acid attack and attempt to acid attack was seriously punished up to death sentence. All these things I will explain in detail in the respective chapter. And these are the various offences under offences against human body. Next one is next chapter is 17th chapter, offences against property. Next one is offense against property. Offense against property we study theft, robbery, dacoity, extortion, dacoity. Offense against property. Theft means if house is locked, house is broken and money taken away, belongings and valuables taken away, it is theft. If a scooter is parked, somebody takes away the two-wheeler or four-wheeler, it is the theft. And robbery. Robbery means people are there inside the home and the culprits knock the door and they open the door. They open knives and they point the knives and revolvers are pointed at the residents, and you give all your property, money, valuables, otherwise we will kill you. The members of the family, to save their life, give all the properties, valuables and belonging. And taking away one's property with knowledge of the owner is robbery. Without the knowledge of the owner is theft. But creating some fear, if you don't give, you will be put to these trouble. That was just like blackmailing. So if the police officer tells this you what the offense you have committed is very serious, when once you go to court, you will be punished like anything. So many people will trouble you. You will be stoned to death. You will be given very serious punishment like that, like that. Inflict some fear by making putting those words and extracting money. That is what is called extortion. And next one is dacoity. Dacoity means group of thieves, just like Alibaba 40 thieves and Gabbar Singh in Sholay movie. They attack the town, and five and above jointly attack the people, and group of people pointing deadly weapons or revolvers, and ask them, insisting them to give away all their valuables and then taking away. That is called dacoity. In that process, if anybody kills somebody, that is a serious offense, punishable with death, punishable with death and fine also. So these are the aspects. So not only life imprisonment and punishment in view of recent criminal amendment acts. Suppose it is a rape case or any other offense against women, for rest medical expenses and rehabilitation of women also. What is the amount required? That amount also will be assessed, and the culprit is asked to, either culprit or the natural heir will be asked to pay that, and that amount will be given to that. Originally, whatever fine is imposed, that fine would go to state government. But in certain exceptional cases, the fine imposed goes to the aggrieved party. But so far as in pursuance of these criminal amendment acts, for rape and other sexual offences, the culprit is required to give huge amount of fine for rehabilitation medical expenses of the victim. This is the position. And now rape, kidnapping is one of the offenses against human body. I forgot to tell you, kidnapping, abduction. Kidnapping refers to child stealing. Kid means child, nap means stealing. Kidnapping means child. If child is taken away, that is called kidnapping. If adult is a man or woman is taken away, it is called abduction. That people commonly use the word kidnapping, but we should not use the word kidnapping in all cases. In respect of child stealing only. Kid means child, nap means steal. Kidnap means child steal. That is kidnapping. If MLAs are abducted, some government servants are abducted to meet their demand, that is we use the word abducted. Similarly, young women are abducted for several reasons. The neglected children, neglected people sleeping in public places are taken away to give intoxicated substance, to take away their vital organs, to be sold at very expensive prices. That is also there. In movies we are seeing that in Yasuda, headed by Samantha, that movie, and so many movies, Tick Tick Tick, some Kamal Hassan's movie in Tamil, and so many movies we are taking how the valuables are being imported through the human bodies to overshadow the eyes of customs personnel. All these things are there. And abduction. A woman are abducted for various reasons, for begging purpose. Children are kidnapped for begging purpose, and the women are transported to various other cities or other countries for prostitution purpose, and so many things are there. In abduction, there are so many sections are there. The persons abducted, how they are trafficked, how the woman trafficking is there, and the child trafficking is there for various purposes. We will discuss in the respective chapters. And next one is offense against property, religion over women body, property. Chapter 18. Chapter 18 speaks about offences relating to documents, property marks, forgery. Forgery. Suppose there are sometimes forged documents are submitted, and forged degrees are submitted to get job, and the authorities who are giving employment could not identify the forged document. give the appointment, the people will continue. And forged PhDs, without doing any work, giving money to somebody and taking the PhD. Or someone takes PhD by reproducing the thesis of another. If the original thesis owner gives complaint, then it will be referred to UGC for cancellation of that PhD. So this, if anybody takes the advantage of forged documents or forged degrees to get any benefit, in the event it is detected, that person will be punished under this chapter 18. Next, 19th chapter is uh, 19th chapter is 490 to 492. 492, criminal breach of contract of service. So when a person joined in service, whether it is a private service or a government service, an employee, a person who wants to join government service, you should give an undertaking to act in consonance with the rules and regulations of the government. If that person doesn't act violates any rules and regulation, disciplinary action will be taken against him. If he is a public servant, he will be given protection under Article 311A, 311 Clause 1. That is the committee is to be constituted for disciplinary action, and after inquiry, necessary report only, reasonable time is given, and all the regular formalities are there. Action cannot be taken directly against a public servant. He may be the chief secretary of the state, or he may be the class 4 employee of the state. The proper procedure must be followed for taking disciplinary action against the public servant. But that type of action protection is not there. Constitutional protection is not there for employee. The managing director of a company can remove the general manager without any without assigning any reason. That is called doctrine of pleasure. Article 310 of Indian Constitution speaks about doctrine of pleasure. Article 11 Clause 2 of the Indian Constitution speaks about the constitutional protection given to the public servants or civil servants who against whom action cannot be taken. But action can be taken against private employees. But serious action, direct termination cannot be taken against public servant. And this is what is called 19. So next one is criminal breach of contract. Chapter 20 containing section 493 to 498. 493 to 498. These sections relate to offences relating to marriage. Offences relating to marriage, time is offence relating to marriage. In offence relating to marriage, elopement is one. Second one is bigamy. Third one is adultery. Elopement is getting married, some false marriage and taking the woman away. But the man knows that this marriage is fake. That woman believes that it is the marriage is real. So meeting with that woman, and that is what is called elopement. That person is that man is punished. That man is punished. Secondly, bigamy. Marrying again during the lifetime of husband or wife amounts to bigamy. The bigamy is punishable for 7 years. For bigamy, if a man has two wives, gets married to second wife during lifetime of first wife, it is bigamy. If a woman gets married to another man during lifetime of husband, it amounts to bigamy. And to more than two house spouses, that amounts to more than two wives is polygamy. More than two husbands. Two husbands is bigamy. More than two husbands is polyandry. More than 200 husbands is polyandry. So bigamy. Bigamy is punishable for 7 years and fine or both. And next one is adultery. Adultery means a man indulging in sexual intercourse with a married woman. Married woman. He knows that she is a married woman, and without the knowledge or consent of his husband. Then when once the married woman's husband lodges complaint, the culprit who has sexual intercourse with a married woman is punishable. But that woman, though she is a consenting party, woman is not punished. Similarly, a married husband whose wife is indulging sexual activity with other man can file a case against the culprit. And similarly, culprit. Similarly, a married woman whose husband is indulging in sexual activity to other woman cannot file a case against the husband for that. So the Article 14 is violated. There is a constitutional. It is said that this adultery, the section 498 is violative of Article 14 of the Indian Constitution, and ultimately the court said that it is not constitutional violation, but the section relating to adultery are constitutionally valid. That is chapter 20 containing chapter 493 to 498. Chapter 20 clause A was inserted by constitutional amendment, criminal law amendment, and this chapter 20A contains only one section. That section is 498A. It speaks about dowry death. Though I am not able to explain detail, all these topics will be explained in very detail with latest developments in the respective chapters, no problem. And starting chapters will not be explained in detail, but these later chapters will be explained in detail. So don't, if I complete it very quickly, don't worry. And then 498, cruelty by husband and collateral. Generally, a woman gets married and goes to father-in-law house, and there everybody will create lot of problems. Husband assaults mother-in-law, sister-in-law, husband's brother, sister, and husband and his collaterals means husband's father, mother, brother, sister, sister-in-law, younger, elder, all these come within the meaning of collators. And when once a married woman goes to a newly wedded house, and then everybody will create torture. That is what is called domestic violence. And for this domestic violence special act also is there. In case dowry prohibition act is there for this, and all the under these special laws and special legislations in special courts, this case can be specifically tried, and the culprits can be punished. That is about chapter 20. 21 speaks about defamation. I explained in detail about defamation in law of torts. I gave Telugu lecture in English and Telugu also. 2 times I delivered lecture defamation. You go through the defamation mean causing injury or damage to reputation of anybody, another person. Section 499 defines defamation with reference to libel and slander. 402 fine 500 prescribes punishment for defamation of with 2 years imprisonment. And there is a constitutional debate. There is a debate that the defamation should be confined to tort only, and criminal liability should be abolished. That is there, but the authorities have not accepted for that. Now defamation is not only a tort but also a crime. That is chapter 21. Last chapter 22. Last but one chapter 22 speaks about criminal intimidation, insult, annoyance. Suppose if by words or actions, if we cause injury or damage to any individual, that person is insulted, annoyed. Suppose in a public party and something, so one person insults, and in one, I physically witnessed in one marriage, one party, some hundreds of people are taking lunch. One rich man insulted another man who was taking food. In the middle of he brutally insulted him. That is such type of activities are called in party. Insulting a woman as some prostitute, and insulting a man as a corrupt or irregular, and that person is annoyed, insulted in such a way as if he will not be able to bend his head high, and he may get prepared to commit suicide also. That type of activities, this is criminal intimidation, insults, annoyance, and all these things come within the purview of section 503 to 510. Last chapter, chapter 23, contains only one section, that is 511. It speaks about attempt. What is attempt? For offense of murder, attempt to murder, though both the punishment is same. For both the punishment is same. Suppose if married woman comes to the home, if father-in-law or mother-in-law or husband or anything, with their words and everything, instigate her to commit suicide, abetted her to commit suicide, they are equally punishable as if they have killed them. So whatever punishment is there, for suicide punishment is same, attempt suicide also punishment is same, murder punishment is same, attempt to murder punishment is same, kidnap or abduction punishment is same punishment, attempt to punishment. Suppose a man attempts to kidnap a child, meanwhile the child's near or dear are found and he is caught but and handed over to police, that person is liable for punishment under what punishment is given to kidnap, same punishment is given to that man. So distribution of money for water in elections is, but the person who is while distributing money and about to distribute money, he is caught by police, that is attempt, he is punishable. Some huge volume of cash is being transported from one place to another to distribute the same to the people for purchasing votes. If that vehicle is seized by police on the way, that is also attempt to that particular offense. What punishment is given to that activity, the attempt also will get. So for every offense, attempt is there, accomplishment is there. If the offense is completed, the accomplishment of the punishment. If the attempt is made, accomplishment is not there, still it is declared as attempt and say punishment will be given. These are the various issues relating to this criminal law, and next class within shortly I will complete this criminal law mainly. General principles I will take up immediately, 3-4 classes I will upload, and all general principles I will upload, and from specific offences I will take. Though these classes were uploaded long back, there will be lot of difference, but I am referring so many research papers and collecting very good information, latest information. So I request you to make use of my lectures. Spare your most valuable time, just 1 hour for 2 days, and complete all the lectures within 1 year. Meanwhile, many more lectures will be uploaded so that you will be able to stand very promptly in court as a lawyer tomorrow and judge day after tomorrow. Wish you all success. God bless you.